For record-keeping purposes, if you wish to make a statement regarding any item on the agenda, please complete the form located at the entrance or at the rear of the council chambers and deposit it with the Planning and Housing Commission secretary. Welcome to tonight's Planning and Housing Commission meeting. I will lead us in the Pledge of Allegiance. Persons wishing to address the Planning and Housing Commission are requested to state their name for the record. This portion of the agenda is intended for public comment. State law prohibits the Planning and Housing Commission from discussing or taking action on items not listed on the agenda. The Planning and Housing Commission will appreciate your cooperation in keeping your comments brief. Please observe a 3-minute limit to communications. Ms. Capilla, did we receive any speaker cards or written comments from the public for any items not on the agenda?
No, Chair, we did not receive any speaker cards nor written comments.
All right. Next, the approval of minutes from the Planning and Housing Commission meeting of August 7th, 2023. Ms. Capilla, did we receive any speaker cards or written comments from the public regarding the August 7th minutes?
No, Chair, we did not.
All right. Is there a motion for approval of the minutes? All right. The Vice Chair made a motion for approval. Do we have a second?
I'll second.
All right. Then let's all vote, please.
Commissioner Sherman, you may vote on this as a procedural item, just making sure.
Okay. Motion passes 4-1. One abstention, that is. Next, we have a public hearing. And the first public hearing is item for SPA 2022-0006, a specific plan amendment to the Northeast Corona Specific Plan, amending sign regulations under Section 4.5.10 I for Planning Area 7A in the Support Commercial Zone to increase the maximum allowable sign area from 200 to 350 square feet, increase the maximum sign height from 50 to 70 feet, and allow for an electronic message center to be incorporated into freeway pylon signs. Amend Section 4.5.10C to allow up to 6 tenants to be advertised on a parcel identification sign in lieu of the 4 tenants allowed by the Corona Municipal Code. And amend Section 4.5.10I to allow for a height of 55 feet for a pylon sign. Applicant is Carrie Batres, Inland Signs Incorporated, on behalf of CPI Properties, LLC. This item is related to the following agenda item, which was continued item V 2022-001, which is a request for variance from section 17.74.040A of the Corona Municipal Code to allow for an increase in a sign area for a proposed off-site directional sign for the Los Arcos Plaza located at 161 to 191 North McKinley Street. We have the same applicant, Carrie Batres from Inland Signs Incorporated, on behalf of CPI Properties. And then for the benefit of time and clarity, staff will provide a presentation that covers both of these applications, and then I will ask the commission to ask questions on the 2 items separately. And presenting here is Ms. Rocio Lopez, consulting planner.
Good evening, Chair Woody and members of the commission.
Thank you for the introduction. As stated, the item before us tonight is a combined item 2 and 3 on our agenda tonight for a specific plan amendment and a variance. This is in regards to Los Arcos Commercial Plaza, located at 161 through 191 North McKinley Street. As the commission may recall, back in June 26, 2023, the commission made a favorable recommendation of approval of the specific plan amendment, and it was to increase the freeway pylon sign from 50 to 70 feet in height, increase the sign area of the pylon sign from 200 feet to 350 feet, and to allow an EMC sign, as well as increase the tenant advertisement on parcel ID signs from 4 to 6 tenant spaces. In addition to that item, the specific plan amendment, on June 26th, the Planning Commission also heard variance 2022-0001. At the time, the request for the variance was for an off-site sign or pylon sign to include 2 tenant spaces. As a result of that not being a permitted use in the code, the applicant decided to continue the public hearing to allow time to revise their sign plan and propose a different project. I'm sorry, or a different design. So what we have before us tonight, in addition to the items that the Planning Commission already recommended approval on, the applicant is looking to do a change to that approved sign plan. And the change does require a specific plan amendment to the Northeast Corona specific plan, specifically the sign regulations. And what the applicant is intending to do is replace the approved 6-foot-high on-site monument sign along McKinley Street, and they want to replace it with a 55-foot-high on-site pylon sign. The applicant has also modified their original variance request, changing their previously proposed 35-foot-high off-site pylon sign with 2 tenants to a 40-foot-high off-site directional sign to be consistent with the code. However, the variance request is still required, and I will mention that a little bit further in the presentation. This is an aerial view of their Los Arcos site. It's a 5.3-acre property consisting of retail shops and some restaurants within the center. Their sign plan as proposed, what the commission had previously seen is their freeway-oriented sign. That sign will be replaced from the existing freeway sign, 50-foot high, to a 70-foot-high freeway sign. Sign number 3 on the plan here is shown is going from a monument sign to a 55-foot-high pylon sign. The corner monument sign will remain at about 4 feet in height, and that proposes 4 tenant panels, and the pylon sign proposes 6 tenant panels. The applicant has changed out the pylon sign, the off-site pylon sign shown as circle number 2 on the plan before you on the screen, to an off-site directional sign. So here's the freeway sign that the Planning Commission previously reviewed and recommended approval to the City Council on. There's no changes to this proposed sign. The sign as proposed is to the right of the screen. To the left is the existing sign. Here are photo simulations of the freeway-oriented pylon sign. The off-site directional sign. This is part of the variance request, variance 2022-0001. And this off-site sign originally was proposed as a pylon sign with 2 tenants. Because it's not a permitted use, variance was not an appropriate means to approve the sign. And so the applicant went back with their sign contractor and amended their plan. And their amendment is proposed before us tonight. It is a proposal for a 40-foot high off-site sign, directional sign, which only advertises the shopping center name and omits the tenants, and has directional signage to direct vehicles onto their property. The applicant is requesting this off-site sign due to the fact that as a result of the McKinley Bridge or grade separation project, a remnant parcel has been or will be created, which is essentially taking part of their property of the shopping center, and as a result is creating a loop road from Sampson connecting onto McKinley Street. And this is a change in their specific plan amendment request, and it's essentially replacing the monument sign to a pylon sign. And this particular pylon sign is being requested at a height of 55 feet with the 6 tenant panels. The applicant is requesting an amendment. Currently, the maximum parcel ID sign height allowance is 40 feet, and that's per the Corona Municipal Code. So the applicant is requesting an amendment to the specific plan. Specifically, it would only affect this planning area 7A within the support commercial zone. And it is not going to impact any other property within the Northeast Corona specific plan. The corner monument sign, as proposed, 4 foot 4 inches in height with 3 tenant panels, advertising the Los Arcos Plaza, will remain unchanged. And this is just a view of the subject site. As we can see, the property is currently undergoing transition, and there's currently equipment for the grade separation parked on site, as well as construction vehicles. The variance request, as stated previously, is a deviation from Chapter 17.44, specifically the signs section of the code. And it's a request to increase the maximum 6 square foot signage area on off-site directional signs. The applicant's proposing a 40-foot high off-site directional sign within the future remnant parcel. The future remnant parcel will be owned by the city and will be used as a water detention basin. The applicant is proposing a total 77 square foot sign area, which includes the shopping center name as well as the directional signage. This variance is being requested due to the McKinley Bridge separation project. And again, the sign would be placed within the future detention basin. Staff has made the findings for the specific plan amendment as identified within the Corona Municipal Code. The amendment is consistent with the general plan as well as consistent with the Northeast Corona specific plan and the development criteria. Because of the grade separation, the bridge will be elevated at a higher elevation than the current Los Arcos shopping center. And so it will create a visual impact or obstruction to the shopping center. So the applicant does meet the findings for a specific plan amendment. And that is the same, the findings are also made for the variance. There are specific special circumstances that are applicable to this project in direct result of the bridge separation project. as well as property being acquired by the city to create this loop road and having impacts to the actual center. So at this point in time, staff is making a favorable recommendation for the specific plan amendment, and that the Planning and Housing Commission find the project exempt from CEQA, California Environmental Quality Act, and recommend approval of SPA 2022-0006 to the City Council based on the findings contained in the staff report and the conditions of approval, as well as that the Planning and Housing Commission adopt Resolution number 2611, approving variance 2022-0001 based on the findings contained in the staff report. And that concludes my presentation. I'll be happy to answer any questions, and applicant is also in the audience tonight. Thank you.
All right. Thank you for the presentation. Very, very informative. Before we open a public hearing, any commissioners have questions for staff?
I have one, Ms. Rocio. On the spa, with the change to the requested pylon sign now, the height of that sign and the number of panels, is that also an exception to the standard code?
That's correct.
And what is the code height for that pylon?
The code permits maximum 40 feet in height,
Okay.
as well as 4 tenant panels.
And so we're going to 55 feet and 6 panels.
That's correct.
Okay.
Yeah, and the commission had already previously approved the 6 tenant panels at the June 26th meeting.
All right, thank you. Those are my questions.
Yeah, I have a question. So we already acted on the item. I just want to understand, exactly what the process was here. So we acted on an item before, and the commission recommended it for approval. But so the approvals, that approval has been wiped out at this point. Is that the case?
I think in an effort to make it clearer to the city council when it goes to the city council, I think just to make it just a smooth, clear process, I believe that was the intent, is to bring it back. Unless Ms.
So
Joanne.
you made a recommendation for approval to the city council, but before the city council took official action, we had met with the applicant prior to that. And because they proposed this change, we did not want, the council could not make a decision because then she would have to start a whole new process again. So it was to pull back and then come back and have you reapprove the specific plan amendment with this added addition of the pylon sign height being increased. So it was like midway there.
All right, good. Thanks for the explanation. And then I know one of the discussions we had previously was about the off-site sign advertising the center, and I know the city attorney was here with us that last meeting and was very clear about how that would conflict with the code. So can you clarify how this is different?
Certainly. So the difference here is it's a directional sign, and that has been allowed in other situations. Ganal is a perfect example where we allowed them to have a direct off-site directional sign. A directional sign can be either on-site or off-site, but it needs to just give directions to a structure, to a building, to a particular site. So when the applicant was here at the last meeting, the off-site directional sign also had 2 tenants on it, and that was the problem, why we could not, it didn't even qualify as a directional sign, plus it was off-site. So those were the 2 issues with that. We met with the applicant, they understood where we were coming from, and that's where this revised application came from, where they took the 2 tenants off. You will see as well on this agenda, you have a a proposed amendment to the municipal code to try to address the issue that I was discussing at the last meeting, where we have to be very careful with off-site signs so that we don't run afoul of our prohibition on billboards in the city.
Thank you for the staff presentation. I appreciate that. I had a couple of questions regarding the, on page 2, where it talks about 1, 2, and 4, but then it made a special note regarding item number 3, where all the commercial properties with the SC designation, this would apply to all of them with that, going from 4 to 6 tenants. Is there a unintended negative consequence with that, with the other SC designations?
Staff didn't see any conflicts or any particular issues with that, with other SE designations.
Okay, thank you. I also wanted to know regarding the conditions of approval listed on the variance. Can I talk about that, Chair?
I think if it's the variance, then we should
Wait until,
probably wait.
all right. Then I'm done.
You could talk about both because we presented them in both, but you could take a separate, you'll need to take a separate action on each one, but you can have a comprehensive conversation on both applications.
Okay, perfect.
Oh, thank you. So regarding the variance, and it talks about the conditions of approval, and where number 3 talks about 2 years of construction to begin, otherwise it'll be expired. How does that, can you explain how that coincides with the construction of the project? For example, if the grade separation, the placement of that sign near the loop and near the water basin, if the construction of that delays at no fault of the applicants and somehow it goes beyond that, should the wording perhaps say the condition of approval will be extended with time when the grade, if and when the grade separation is delayed, so that that buffer in time is in favor of the applicant or doesn't penalize? How does that work?
It's my understanding, and well, per the Corona Municipal Code, the applicant can request, I believe it's 1-year extension of time. I can't recall if it's longer than that, but maybe our director or city attorney can address that.
As you are talking, I'm going to look it up on the CMC real quick, but, and see what language we can possibly add. So let me go ahead and look that up while you guys are talking.
All right, I guess my point is not only for it to expire and penalize the applicant at no fault of their own, but perhaps is there additional fees for refiling for an extension? Is that, how does that impact the applicant, I guess is my other question.
So yes, there is fees to file an extension, similar to the CUP extensions you have filed that you've heard. Those are a fee. If they're coming up on an expiration of 2 years, they can come back and ask for another 2 years. So it really depends on the status of their project and possibly market conditions. So yes, they do come back. So what the CMC says, there is a limit of 2 years, but it's nothing, it doesn't say that you are, if you want to go ahead and allow them that 2 year from the time of completion of construction, we could do that, absolutely.
Great, that would be great. That would satisfy my concerns there. And I had one question regarding the pylon that showed from 4 to 6, all lined up like that. Is that the same area, but they have to put a smaller font, or how does that work?
Is that the 55-foot high pylon sign that's being requested, or you're referring to the corner 4-foot 4-inch high
No,
sign?
not the corner, but the pylon. I just was curious of what the requirements are on the size And if they're being allowed 6 tenants, but it has to be smashed in the same area that would, compressed in the same area that a 4-tenant would be, or how does that work?
Looks like their tenant spaces are within 13 feet approximately, so they're each allowed 2 feet in height.
So it wouldn't matter whether it's 4 or 6?
I think if it's 4, they'd probably get more of a height area, but they could certainly increase the sign area. Let's see if I can go back.
I mean, my point is that if the point of the pylon and the 6 tenants is to give more exposure to current tenants, then it kind of is a mood issue if you're squishing it down and it's less visibility, I guess is my concern.
Yeah, I think they're actually increasing the, I don't have their previous monument sign for that area, but previously it was a 6-foot high with 6 tenant spaces. But I think what they did is because the monument sign was a little bit wider, I believe they were able to get, I think it was 3 and 3. And so because this sign is actually taller, they're able to just put them in vertically.
I just want them to be able to benefit fully for full height versus compacting the font. Thank you. That's all, Chair.
Forgive me for not being on the same page as everyone else. I've been staring at the images, and I need to know, because this has been a while, I need to know this. The signage, where will it be in relation to the off-ramp? Is it making sense because they're going to pass it anyway? Will there be a loop to come back? I don't understand. Haven't seen a picture of that yet.
Yeah, let me see if I can pull up the, let's see, the overall plan here. So this is an aerial view of McKinley Street, and then there's Sampson, and then, of course, their property is to the right of the screen and kind of this orange area. And so if you're coming south on McKinley Street, you will essentially be heading toward the right as you approach Sampson, because the ramp essentially is going to be pulling up almost kind of where number 3 starts, or the circle number 3 is. So that is where the McKinley Street ramp will begin to ascend. And so in order to get to their shopping center, the directional sign that's under Circle 2 will direct you to stay right on McKinley Street. And when you stay right on McKinley Street, it'll put you out at Sampson Avenue. And so on Sampson Avenue, you essentially would do a U-turn to get back onto Loop Road, and then the directional sign will direct you turn right on, and it's not going to be called Loop Road, it's going to be called another Paseo, let's see, it's on the directional sign. It's got another street name, but essentially that directional sign will direct you to the Los Arcos Plaza.
Well, I meant the freeway sign, the number 1.
Okay, I'm sorry. So the freeway sign, let's see if I can go to the photo simulations.
It will be after you've passed the McKinley exit.
Yeah, and I think what they're doing is they're keeping the sign at the current location. They can't have it any closer because it'd be considered an off-site sign. So this is actually within their property.
Yeah, the answer to your question is yes. It would be past McKinley if you're going eastbound. If you're going westbound, it would be before McKinley, I believe.
So then to answer
I believe.
my next question is, what benefit will it be? When will they will go to Pierce? And then there will be signage at Pierce saying to come back?
Well, I would say that you would see the sign from farther back if it's taller or larger, right? So you have a better visibility from a distance in part.
Okay.
So I couldn't tell you when, without experiencing it myself, where you would start to see it. Plus, my eyesight's not that good.
Yeah, that's mine too. So I'm thinking, just how high does it have to be? I asked that question at the last meeting. it will be illuminated to be able to at least see that there's a Los Arcos Plaza in some of the shops and their signage that we can see before we exit. Okay.
Yes.
I would point out that one aspect of a freeway sign isn't necessarily that you necessarily see it as a directional sign. It is a marquee. So if you live in the neighborhood and you drive by it, you may see that there's a certain tenant there when you drive by one day, and may remind you on your way back that there's a tenant. So it is a landmark type of sign. The freeway sign is not a directional sign to direct you. It is just to identify the shopping center as a place, if that makes sense.
I had a follow-up question that came to mind. Ms. Lopez, could you go back to that site plan, the slide before you showed this one? There, thank you. I just wanted to confirm, I believe that the eastbound McKinley Freeway exit is also being aligned or widened such that you can traverse from that over to the new loop road. Is that correct?
I believe that's correct. Unfortunately, there's no one here from traffic to confirm.
Yeah, because I remember looking at the original plan and looking at the construction now, they definitely appeared to be widening that off-ramp. And what I couldn't find anywhere is if a lane actually allows you to traverse to the loop road.
Yeah, I don't believe we looked into the issue of lanes as a matter of this sign proposal.
Thank you.
Okay, well, if we're finished with questions for staff, then I guess we will ask about any speaker cards or written comments from the public. Ms. Capilla?
We have one coming up.
So as far as going straight from the loop road from the exit, you cannot. The only way you can get to the shopping center coming east off the exit is to make a right on McKinley, make a left on Sampson, and then make another left onto the loop road. Yeah. I didn't know if anyone else had any other questions for us, but as far as the sign height, we're taking it to 70 because we feel that you'll be able to see it before you exit going east on McKinley, and it's going to be pretty much in the exact location that we have the current sign right now. That's along the freeway. I don't know if any.
Okay, and I'm sorry, I'll just say the public hearing is now open.
Oh my God, I'm so sorry.
Anyone wishing to speak should come to the podium
Sorry,
and
Woody.
speak after Ms. Padilla.
Sorry, Matt. But I think that was it, so. Good.
So I guess I'm curious, and the changes versus what came before us before was basically the one monument sign is now being submitted as a 55-foot pylon with the 6 tenants, right? That's one of the changes, and then there's the offsite sign as well.
Right, so we're still going forward with the off-site sign since we had the application in, but we'll be going over the next one that I think might give other clarification.
And then was this, the off-site sign, was it similar to this, but it just had tenants on it, and that was removed?
Right.
Okay. Any other questions for the applicant?
I don't. Thank you.
Okay, thanks.
Okay. Ms. Capilla, do we have any other speaker cards for this item?
No, Chair, we do not.
Okay. Then I guess I will close the public hearing, and then we will have the commission make comments. And if you wanted to ask your question now.
Sorry, I'm out of order. I did have a question, Ms. Lopez, regarding the condition of approval under the Public Works section. And I noticed they're not here, but maybe you could, or someone could address what number 2 means. And it reads, prior to the issuance of the grading permit, the applicant shall demonstrate to the satisfaction of Public Works Director that the proposed project will not unreasonably interfere with the use of any easement, holder of the property. Isn't that already been looked into already at this point? I don't know what that means, I guess.
No, so what this will allow us to continue to negotiate, and I think a lot of this will be vetted out through the negotiation process, but it leaves that open for us to continue when it's finally said and done and all the alignments are into making sure that wherever this sign goes, it's in a location that is acceptable to the Public Works Director.
So if it is not, then
You just don't know if it needs to be moved around a little bit because maybe there's some easement there or something like that.
Okay, thank you.
And then I guess I have a question also for staff. So the off-site directional pylon, that will be located on city property? So the city will be the owner of that sign?
No, that is an item that will still need to be worked out because it is city property, so the city will have to give some kind of permission, or we do that by easement or a license agreement. But that is still subject to discussions with the applicant and whatnot, pending what the commission's decision is.
Okay, so we don't know if ultimately that will be city property, or I thought...
You know it will be city property, but in terms of the vehicle or means to give the applicant the right to have a structure on city property, that will be handled separately.
Okay,
It'll either be a license agreement or an easement or something of that nature.
I see.
I just wanted to make a comment, I think, on the specific plan amendment, the change to a pylon sign with tenant spaces seems to me like a good solution to the challenge that confused us before about how do we get around having an off-site sign with tenant spaces and the inconsistencies that would give within the city. So I think, my opinion, I think this solves, at least on the SPA, it solves that dilemma that we had before us from our meetings back in June. Those are my comments. Thank you.
I also agree with Commissioner Sicklin, and, I don't take it lightly that we're amending the SPA. It's been in place for the center for reasons, but I think with the unique circumstances with the grade separation and the negative impact it's had, potentially imploding businesses in the area, considering the void it's going to create down there. And I do think that the staff assessed the visual impact from the freeway to expose the height and how it's in scale with the surrounding freeway signs. I can appreciate how they also looked at the other zones for commercial centers that have frontage to the freeway and it being consistent and in scale with their standards, and identifying what those centers were and what the allowances were. It was very helpful for me in the consideration. I did want to say that I think maybe this is a separate issue, that in your presentation on the slide pages 9 through 11, where it's showing all that green screens, and I know the city's economic development has been reaching out to the businesses in the area. I just think that that's a lost opportunity for advertising for the tenants that are there, that are sticking around, sticking through the construction and the whole mess that's going on down there. I think that is an opportunity to advertise, but because in all of those elevations that you showed, north, west, south, and east, that's a possibility. I am curious, I guess, if the applicant showed the plan to potential tenants, and if it, with this new signage, if it was any changes in their thoughts of refusing to become a tenant there due to the difficulty of not being able to advertise, I guess was my one question. Other than that, I do agree with you, Commissioner, regarding the compromise here. I think it's a good one.
Okay, well, any other comments from the commission at this point? The only thing I will add is, I'm not quite getting there on the fifth finding. That was the same concern I had last time when we looked at this, as far as the scale of the signage for this type of shopping center. And I thought that the other ones around the town that were mentioned in the report were different scales of shopping centers, but that's where I'm at on that. But I will entertain a motion from my fellow commissioners.
I propose a motion for approval of SPA 2022-006.
I'll second.
All right, we had a motion from Commissioner Sickland, seconded by Commissioner Sherman. Let's please vote.
Commissioner Alexander, how do you wish to vote? Commissioner Alexander? Oh. Oh. I do, thank you.
All right, the motion passes 4-1. All right, next up then, we will consider the variance 2022-0001. Do the commissioners have any further questions? I know we sort of overlapped the questions, but before we open public hearing, any questions?
No questions.
All right. Then I will open the public hearing now. Anyone wishing to speak should come to the podium. Ms. Kapia, do we have any written comments or speaker cards?
The applicant wrote both applications on her speaker card.
All right. So, and do the commissioners have any further questions for the applicant then at this point, or does the applicant wish to make any further comments?
Well, to answer Karen's question from earlier, they're still wanting signage on McKinley. So as far as the directional sign is concerned, that for the variance that you were questioning as far as with brokers or other potential tenants, they would still prefer signage on the McKinley Street. Yeah,
Thank you.
but that was it. Thank you.
All right, then we will close the public hearing and bring it back here to the commission.
Chair, if there are no other comments from the commissioners, I'd like to go ahead and make a motion for the variance with a condition that the 2 years would be added on to the end of construction as far as the starting of the build on the sign.
Okay, well, then we have a motion from Commissioner Alexander. Is there a second? All right, seconded by the vice chair. And then let's please vote. Okay, the motion passes 4-1. Then we are finished with that item. We will be moving on to administrative reports, and looks like that will be from Ms. Lopez again.
Thank you. Thank you, Chair Woody. The item before us under administrative reports is a request by CPI Properties to consider a proposed zone text amendment for, in pertaining to signage. So the request that the commission is looking at tonight is to process a zone text amendment to Chapter 17.74 of the sign regulations within the Corona Municipal Code, specifically Section 17.74.040A, which refers to directional signage within the municipal code, specifically regulations for directional signage for properties that are affected by public improvement projects initiated by the city. Oh, there we go. Okay. Just a little bit of background of this item. The applicant, who is also the applicant for the specific plan amendment and the variance that the commission just heard tonight on the agenda, Los Arcos. This is a 5.3 acre commercial center owned by CPI Properties. The center has been affected or is currently being affected by the McKinley Street Bridge project. And as such, the applicant is requesting an amendment to the regulations specific to properties that are affected by public improvement projects initiated by the city that result in properties being bisected due to eminent domain processes or proceedings, creating visibility as obstruction after the completion of the project as well. This is a view of the applicant's site, just for reference purposes. And this just is background stating that the applicant submitted a variance application to increase the sign area for the directional sign or for their proposed off-site directional sign from 6 square feet to 77 square feet. And the applicant has indicated that if the zone text amendment were to be approved, there would only be one off-site parcel being constructed. The applicant is requesting a text amendment to the to this section 17.74.040. And again, it specifically refers only to directional signage. Currently, the code does permit directional signage with a maximum sign area of 6 square feet. The applicant is seeking to amend this section of the code as underlined in red area or in red italics font. And they are seeking to increase the directional sign to a sign area of 100 square feet with a maximum height of 40 feet. If all of the following criteria are met, and essentially it lists it from A through G, but essentially it pertains, it's very specific, as our Assistant City Attorney mentioned. We definitely don't want to amend the code where it opens the window up to this being seen as maybe kind of a billboard opportunity for other businesses in town, shopping centers to take advantage of this type of text amendment. So items A through G are very specific in terms of who this would apply to. So for instance, item A states that the parcel of land to which the directional sign pertains is bifurcated as a direct result of an eminent domain proceeding in connection with a public improvement project initiated by the city. Item B states that the visibility of the parcel of land to which the directional sign pertains is directly and significantly affected by the public improvement project initiated by the city. C, the directional sign is located on land which had been a part of the parcel of land which was bifurcated as a direct result of the public improvement project initiated by the city. D, the directional sign is located within 175 feet of the closest edge of the parcel of land to which the directional sign pertains and gives directions only to the parcel. E, the directional sign identifies no more than 2 non-residential tenants or businesses operating on the parcel to which the directional sign pertains. F, a maximum of 1 directional sign shall be permitted per parcel to which the directional sign pertains. And then finally, G, no part of the parcel of land to which the directional sign pertains is zoned or used for residential purposes. So this is the proposed language to the text amendment. The zone text amendment process, essentially per the Corona Municipal Code, essentially states that the Planning and Housing Commission must first make a motion to initiate the proceedings prior to processing the ZTA and holding a public hearing. If, therefore, the Planning and Housing Commission makes the motion tonight and it passes, the Planning and Housing Commission would then direct staff to process the ZTA, and the applicant would need to submit a ZTA application to the city for processing. And this is the proposed off-site sign, and it's very similar to the variant sign that the Planning and Housing Commission just approved, with the exception that this off-site sign, directional sign, would also include 2 tenant spaces. And that concludes this report, and staff is happy to answer any questions the commission may have.
Thank you, Ms. Lopez. Who drafted A through G?
Our office assisted with, the applicant gave their suggested what they wanted, and then we tried to turn it into more municipal code type language.
Okay, the question I have is A through G is so specific to this planning 7A area that this would not be a broad stroke for other applicants to go through the same process, or how does that impact?
To the extent that we had a similar situation, yes, but what we wanted to avoid is having anyone who's ever subjected to any kind of eminent domain proceeding for a public improvement project to assume that they get a new sign or they can have, an off-site directional sign. This, we did craft it in response to the applicant's request and with this particular project in mind, but technically, if we have a similar situation, it could be used for that. But we do want to draft it narrowly for the specific reason of not creating an opportunity for a billboard, somebody who wants a billboard to say, oh, you no longer have a prohibition. So we are trying to be very careful on how we draft it.
That makes sense. Thank you.
A question. So the ask is for a motion to proceed with the process. If I or others on the commission were to have a question or a concern about any of the items, tonight wouldn't necessarily be the time to present that. It would be at the time if it does get approved and then the motion is before us officially as an item. Is that correct? Or are you actually asking for input tonight as well?
So this is an amendment to the municipal code that's actually being initiated by the public. So this is where they're coming to you and asking, do we even continue processing this based on what you're seeing tonight? So if you do have some concerns with it or what you think you would like to see, you do want to voice that, because they certainly don't want to spend time going through the process if they're only going to come back here and maybe not get the amendment in a favorable conditions. So that's really what this is. It allows them to vet it out. This is a lot different than when staff is bringing you amendments to the municipal code because it's a project or program we have been working on mostly with the council or some state legislation. This is actually their request to change our current law. So if you do have a concern or some comments, we do want to hear them. It doesn't have to be in great detail, but what are those concerns?
All right, thank you. Yeah, that clarifies it. So for me, of the items A through G, I'm questioning why letter E was added, putting back in the tenant signage. If that really is not the city's intent to have that ability, why was it added in this case?
Yeah, so that is what distinguishes this sign from the variance that you just took action on, right? So that all I can say is that's what the applicant's request is. So that's what they're asking for, is that an exception be made in these very specific situations where you have a parcel that's been bifurcated, it's no more than 175 feet away, that they have this opportunity to have this sign. So that's the reason it's in there.
And so that goes back to the question I think I asked you at the beginning. Under the code, having the tenants is not allowed, and a variance doesn't fix that. And so this zone text amendment is essentially asking us to consider changing the code so they can then go ahead and have the sign that wouldn't have been allowed, right?
That is exactly correct. It is changing the code. Again, not to get into all of the legal detail, but again, we always have that concern of opening the Pandora's box to these types of billboards. And again, that is why we have crafted it as carefully as we can to hopefully not ever have that situation. But we do feel comfortable that if we have this type of strict language that we can defend against that. But that is the reason it's drafted that way.
Because I have a question regarding the reason why the wording was put in such for directional as it was. What's that foundation with no tenants on it? What is that? So give me some context here.
Is your question our original language, or our current language right now is
Correct.
to not have? Again, it's because you don't want to have advertising. You don't want to have off-site advertising. You want to have directional signs are to be directing people to a building, to a structure. So yes, this would be deviating from that situation or from that regulation.
So on one hand, trying to give the applicant as much advertising for businesses that they can, yet because of the unique circumstances of the grade separation, and yet it is a unique situation, and that's why it's A through G. So I get it. Thanks.
And you can take commentary during administrative report. You don't have to open a public hearing. It is allowed, so you can hear from either the applicant or the public. But as you had heard previously, there was still a need from the people that they have been talking to have the tenant ID from McKinley Street. So it seems to be a driver for them on trying to reestablish some uses on the property.
I know that you stated that this is crafted in such a way that it doesn't open up additional situations in the future, but things will happen in the future. We don't know what they are, but there potentially could be a similar situation like this that comes forth. And I guess one advantage of having gone through this and potentially doing this is maybe it sets some sort of standard up in the future that we can follow if we had a challenging situation like this. Would you say that's correct or not?
That's correct in the sense that, that kind of what we talked about the last time. The council and you as a recommending body have the authority to change your law. It is the city's law, so that is certainly an option, yes.
Okay.
Do we know have there been any other, in the past, any other parcels that were bifurcated as a result of a city project. Okay.
Well, I'm thinking Ganal lumber, right?
No, they were not bifurcated. The street was vacated and realigned per our general plan. No, but we have had extensive grade separation projects, I can tell you that. Grade separation projects do change the visibility of a property. Surface Club is another good example. The minute you're driving, it elevates, and an industrial building that was once at grade is now below grade based on the ramp that they had to put in across that grade separation. So we took property from that property at that time, but I don't think it was bifurcated where there was any remnant because that street was so wide.
And wasn't there something that came before us earlier, and Craig, maybe you can speak to this, for Calco for the signage because of the on-ramp there that they added, not
That
necessarily
was, when
city,
they had to raise the
but they
height
had
of
to
the
raise
Bedford Center.
the pylons there. Okay.
All right, if we're done with the questions for staff, I will open a public hearing, and anyone wishing to speak should come to the podium. I do have one speaker card for this item so far from Mr. Morgan.
Afternoon, everybody. Thank you for the hard work putting this together. I appreciate it, and I think it's written very carefully. What I do wish this was a staff report. I wish this was a staff project. The city made this mess. I know it wasn't planning that made the mess. It wasn't community development, but it was the city that made the mess, and I think, have an obligation to help fix the mess. And, it shouldn't be on the applicant to just have to fight and claw and jump through all the hoops just to try to almost be made whole. This has happened before, and it did happen with Ganal. It didn't get bifurcated, but it did happen with Ganal. It's gonna most likely happen elsewhere in another situation. There's gonna be other projects, and there's gonna be other property owners that are gonna be damaged by city projects. And so there should be a way, and if this is modest enough of a proposal that, maybe this should be a city initiative. I'd really like to see a recommendation that this is a good idea or this is reasonable. I see staff recommendations on pretty much every single item. I don't know why there's not a staff recommendation that this is a good idea for this one. It chaps my ass just a little bit that they made the mess, the city made the mess, and seemed to be relatively unwilling, unless pushed, unless cajoled, to actually fix it. We should be working to try to help make people whole that were damaged by this project. So I hope you approve it. It can go through the process like anything else. Thank you.
Okay, Ms. Capilla, any further speaker cards?
Yes, Ms. Vacaro's coming up.
Yes, and I wanted to apologize to her that I called her by the wrong name earlier.
Oh, trust me, there's lots of names I've been called. That one's just perfectly fine. So obviously, if I would have known a long time ago that this is the path we needed to go with, I would have tried to do the amendment for the municipal code before we even brought plans to you guys to make it less confusing and complicated. But right now, again, we're just trying to make sure that we have visibility of the center, that we have future tenants that are going to look past the 3-point turns that we have to do to get into the center since they can't come straight off the freeway, and visibility on coming over the bridge and going through the bridge will hopefully get them there. Ganal Lumber, the example we've used before, they're not advertising their building. They're advertising that Ganal Lumber that sells, like Lowe's, is in that building. So in the event that somebody moves into Ganal's building and Ganal owns the building, the directional sign is not going to say Ganal Lumber. It's going to say whoever the new tenant is in that building. So what we're asking for is, no one cares that it's the Los Arcos Shopping Center. We all care, where are you going? I'm going to the Costco Center. Where are you going? I'm going to the Target Center. Or, so what we're trying to do is that if we can get some larger anchor tenants to replace the two that were taken out and give them that additional visibility and signage, we're hoping that will maybe bring them in. Thank you.
Okay. And with that, we will close the public hearing, and we'll let the commission make comments, and then we'll go from there. So I'll say my comments here. I'm concerned by how specific the language is in this, and I think Commissioner Alexander, I think she was touching on that as well. Just my view is that the ordinance should be written broadly and not so specific. And I understand the city's intention in writing it as crafting the language this way, but it seems like it's sort of a written just for this particular property. And even though we don't know what could happen down the line, none of us seem to recall any other similar properties that have been affected like this. So that's all I have at this point to say, but I'll listen to other commissioners.
Well, since you brought it up, I'd like to reply, please. I don't mind that it's so specific, and I'll tell you why, is because the grade separation was very specific in how it negatively impacted this center. I would take it even further. I don't think it's far enough. I don't think the applicant should be paying for this process to move forward with the ZTA if we vote for it to open up and for the process to start. I think it should be something that gives the center a way to somewhat balance, if it's even possible, the devastation that's happened, the loss of the tenants. It's something that the city felt strongly about. I listened to the reasons why the grade separation was going through. I agreed with it. You can't impact north-south traffic with multiple increasing percentage of rail activity. That was discussed and it was being projected. And this business could thrive, but we're not doing it any favors by penalizing it, further penalizing it. So I'm okay with it being specific because there was a specific victim here, if you want to call it that. So I'm actually in favor to open up the process and let it proceed, and where the chips fall, they may. But I'm okay with starting the process.
Any other commissioners wish to comment?
Yeah, it's interesting. I'm listening to both my fellow commissioners. I'm kind of hearing both sides of it. I don't think we should ever take lightly changing the law or the code to meet a unique situation. I don't think any of us want to 10 years from now be looked back and say, well, why did you approve that, or why didn't you approve that? You did it before for Ganal or whomever else was in the past. But tough things do come up, and bodies such as ours have to figure out how to solve them. I think having a zone text amendment is helpful. Maybe even adding just a criteria that says, maybe not as specific as these items are, but that if it's of a nature that the entire center is changing, that literally every tenant is going to be directly impacted, be it whether it's traffic flow or visibility. There'd have to be some way that says if more than 70% of the parameters of this site change, then there should be special dispensation for that landlord. And whether it's signage or CUP, special attention on CUPs, So I think this is an opportunity. So one, I think motioning to move forward so this can be vetted and discussed publicly and reviewed, I think makes sense. But I think we should also consider, is this an opportunity that there is now a tool for an applicant and the city, the next time this comes up, to say, oh yeah, here's some steps that can be done so that we don't have to have multiple meetings and spend thousands of dollars for application fees. You know, this could be that opportunity for the next time this happens, that there's a toolkit available for both parties. So, but I think it makes sense for us to move forward with recommending that this proceed, that, and allow that opportunity to take place.
I agree. And the reasons that I wrote, and Commissioner Karen, as well as Craig, said something that caught my attention. I wrote, if this were eminent domain for public health and safety, emergency medical, that would be something that the applicant should not bear the burden financially. But if it's for, I mean, the railroad, maybe they could have contributed to remuneration to the applicant. If it's public health safety, I am not privy to past meetings in the city council, but I do believe that it's specific, but maybe not specific enough, because it should address who's responsible for it if it's just eminent domain. If it's maybe emergency, that's a different thing.
I can see your point, but considering that there's still negotiation going on, there's still a legal process, I can understand the city wanting it so specific that they're comfortable with this exception and that it's not going to be duplicated multiple times. It's a very unique situation, and I'm okay with the process opening up.
I am too.
Commissioner Sherman, any comments from you? Okay. So do we need to have a motion, or how would this?
So we are asking you just to provide us with direction as in the recommended action, but I do want to comment on the application fee. Fees can only be waived by the city council, so it's not that the applicant, they can always request as it goes through the process. So for example, let's say the ZTA does come back before you, they will have to apply for that application and fully pay for it. But when they go to city council, they can let staff know that they would also like to put in a request at the time it goes to city council to have the application fees waived, and then they can make the decision as to whether or not they want to waive the fee. And normally what happens then, we are allowed as staff to process a reimbursement. So that has to be part of the city council action, but it cannot be part of this action. They are the only body that can waive the fees.
Thank you for that clarification.
And then, so do we need a motion and a vote?
I think we just need to know, I think what I heard 4 were in favor of, I heard Craig Sicklin was in favor of moving forward with the request, Commissioner Alexander and Commissioner Vernon, so I have 3, and Commissioner Sherman, are you, so I think we have, and Chair Woody?
I'm not in favor,
Okay.
but we have a majority.
So it sounds like we have a 4-1 to move. Okay, so we will work with the applicant on coming back and getting that done. Thank you. And I
Okay.
do have another admin report, I'm sorry.
Okay, well, before we entertain that, I accidentally skipped one section on the agenda for written communication, so I just wanted to ask if the Planning and Housing Commission Secretary received any written communications from persons providing information or seeking action by the commission.
We did not, Chair.
Okay. And then I will turn it over to Ms. Coletta.
So I don't know, so for you to know, Jay Eastman is leaving the city of Corona. He has accepted a position at the city of Tustin, which is 7 minutes from his home. So He gets to enjoy a very short commute, but it was a promotion over at the City of Tustin to be the Assistant Director for the Planning Department. So this is his last meeting with us, but I just wanted to let you know that was a decision he made about a month ago. So he's been helping transition, and I just wanted you to know that. So.
Well, congratulations, Mr. Eastman. You will be greatly missed, and we wish you luck in your new job.
Thank you very much. I do want to say that I've appreciated all of your time and your comments and your leadership. And so you have a very great commission, very diligent, and it's obvious every time there's a meeting that you care very much about the community and you put the time and the effort in. So I have appreciated that very much, and I've really enjoyed working here with the city. It was not my intent to leave the city. It kind of fell in my lap, and it is my hometown. And it is very close to where my kids go to school and where I can, enjoy quality of life. So it worked out, but it wasn't something I shot for. So I do appreciate all of you, and thank you very much for your time.
Well, I'm not a tiller, but I do wish you well in Tustin, and I've enjoyed working with you and your input and guidance to the commission, as well as Ms. Coletta. So best of luck, Mr. Eastman.
Yeah, good luck to you, Jay.
Okay, thank you very much.
I want to say thank you for, giving me my orientation, made me really feel comfortable about it, and I'm going to be sad to see you go, but congratulations.
Thank you.
Yeah, and I will add my voice to that. You've done a lot for us here and for the city. So definitely, Tustin's gain is our loss, and Ms. Coletta's loss. Apparently, she will probably have a higher workload. So thanks, Jay. Thanks for everything you've done for us.
Thank you.
Do we need to go over future agenda items or no? All right, perfect. Well, then with that, we will adjourn the meeting. The next meeting of the commission is scheduled for Monday, September 11th, 2023 at 6 o'clock here. Thank you, everyone.